Well, good morning, everybody, and thanks for joining us today for our coffee break. I hope that you brought your cup of joe and a snack if you like. We are excited today to have Ron Lospennato here from the law office of Ron Lospennato. And he is an attorney that's local to us here in the New Orleans area. And he has many years of special education law in his background. So we're excited to hear from him. We generally do not take questions for these short little 15-minute coffee breaks. So if you have questions and you want to drop them in the chat as we go, I will send those to Ron, and we'll hopefully get answers. He also has a PowerPoint and will be giving you his contact information so that you can shoot him an email. He's very easy to reach, and he said he loves to brainstorm about issues and try to help folks out if there's just a question that you have. All right. So Ron, thanks so much for being with us today.
Happy to be here. So I guess with school starting up, this is a really important issue. I'm going to start off. The title of this is it lawful to refuse to provide a child care services because of a disability? So the answer to that is very rarely. And now I'm going to try to explain why that is. The one thing I would say is that this area can be somewhat complicated because there are so many variations of childcare types of facilities and who runs them and who doesn't and what their criteria are. So like everything else under the ADA and Section 504, the judgments have to be highly individualized. So again, that calls for a lot of variation. But that being said, let me move for some reason my screen is not. Okay.
Are you not able to advance your slides?
Yeah, so for some reason, there we go.
There we go.
I just have to hit it harder. Anyway, so there are two laws that apply, although the ADA actually is divided into various titles. And what we're really talking about under the ADA is Title II and Title III. But the two laws really are Section 504 and the ADA, and within the ADA, there's Title II and Title III. Title III of the ADA applies to places of accommodation, and almost all child care settings are places of public accommodation because they just admit children from the general public. It's not a closed club or anything like that. Section 504 of the Rehabilitation Act, which was enacted in '73, and the ADA didn't come along until much later, in 1991, prohibits discrimination against people with disabilities in programs receiving federal financial assistance. Virtually every school district you're going to run into is going to have federal financial assistance. So that is pretty sweeping coverage. And then Title II of the ADA covers any public school program as well. And it doesn't really matter whether or not they receive federal financial assistance. A Title II entity is any entity of state and local government. Now, there are some tricky questions even there, such as with charter schools and the like. But by and large, any public school, anybody accepting students on a public basis is going to be covered by either any one of these three statutes. The ADA specifically lists places of accommodations as being a nursery, elementary, secondary, undergraduate, or postgraduate private school or other place of education and daycare centers. And so it's a very broad definition. These private entities are considered places of a public accommodation because as I mentioned, they hold themselves out to the public. And a child care provider, whether operating out of a center or a family child care home, is a place of public accommodation. So it doesn't really matter where the service is being provided as long as they hold themselves out to the public. There is there is an exception for religious entities. So child care programs run by religious entities, as opposed to simply housing a program, they would be exempted under the ADA. However, they're not exempt under Section 504. If they receive federal financial assistance, then they are covered by the ADA, by Section 504, and the same non-discrimination requirements apply. And based on my personal experience, most Catholic schools will be receiving federal financial assistance, usually in the manner of a school lunch program. But they definitely receive the money. And as I mentioned, that Section 504 has the same standards as the ADA. Hold on one second. I had to deal with some background noise. Anyway, okay, so under the ADA, there are three types of accommodations. What I mean by the accommodations in this context is reasonable accommodations. There are changes in policies, practices, and procedures, provision of auxiliary aids and services to ensure effective communication, and the removal of physical barriers in existing program facilities. Any one of those things that are necessary in order to accommodate a child with a disability needs to be done, with few exceptions. So when is an accommodation not required? An accommodation wouldn't be required if it fundamentally alters the nature of the program or services offered, or would pose an undue burden. And undue burden is typically a financial test. In other words, is it going to be too costly to provide the accommodation? Again, it should be rare that a child with a disability would not be eligible for child care based on those standards, because because the programs carry a very heavy burden in proving that the nature of the program would be fundamentally altered, or that they would have an undue burden. And I think part of and again, it's hard to, I mean, I'm sure that when children are being denied services, it's often that they'll pose these issues. But I think it's helpful when you look at it to really become familiar with what the program is and who it provides services to, and the like, and then you can start to analyze whether or not it's really as big a change as they often will contend. In practical terms, what is reasonable will vary. The variables, as I mentioned, are the needs of the person with a disability, the type of accommodation that's being requested, and the accommodations available to the program. So in a public school program, since if it's run by a public school, there really shouldn't be an issue, because schools already have obligations under the IDEA and other laws to provide a whole range of services and accommodations. And so that isn't an issue. If you're talking about a small daycare center that's run in a private home, then obviously you're going to have, there's going to be a little more sway to the argument that it's a fundamental alteration or an undue burden, if it really is very difficult to do, or it's very expensive. But so it really will vary a little bit on the nature of the program you're looking at. And again, I think that because there are so many variations, if people have questions about whether or not an accommodation needs to be required, or about a policy and practice that seems to be excluding a child with a disability, please let me know, and I'll be happy to get back to you and at least analyze the issue, because they're really important issues. I mean, it's so critical for families to have for financial and other reasons, to have these programs, to have after-school programs and before-school programs. So I'd be happy to answer any questions people have. But again, there are variables, and it's important to look at those variables. And what's also helpful is, if you have a particular issue, is to get a good sense of what is available, the resources that are available to the program, because it makes the discussion go a lot easier if I know what sort of the lay of the land is, or any lawyer or any advocate really needs to have that information. So what's some common types of accommodations? Change in toilet training policy, for example, to assist a child with Down syndrome who, due to the disability, requires assistance going to the bathroom. Change in discipline policy to ensure that a child with autism has equal access to a program, or an emotional disability for that matter, with appropriate supports, such as staff training and aid in de-escalating behavior when the child acts out. Changes in medication policy, so that a trained staff person can assist the child in the administration of medication of various kinds. The example given here is diabetes. Yeah, so I think that those are, on the change in medication policy, sometimes what you're going to run into is, nursing standards, and what can be administered and what can't be. And those are things that require some analysis. So if you have that kind of complicated situation, I think that it would be important to get a sense of what the training of the staff currently is, and what the nursing standards would require. So other types of accommodations include appropriate aids and services needed to effectively communicate with children or adults with disabilities. If the child care center, for example, is closing early due to bad weather, that may mean using a different method to contact the parent. If the parent is deaf or hard of hearing. And if a child care center uses websites or parent portals to keep parents informed concerning the child's participation, all the technology that they use on the website needs to be accessible, so that anybody with a hearing or vision or speech disability can use that portal. Finally, accessibility. This is obviously a common issue. And sometimes it's very simple to make it's simply a matter of moving furniture around. Sometimes it's a little more complicated because it's going to require some level of construction. And again, just because it costs money doesn't mean that service isn't necessary. In fact, if the cost is relatively small, virtually any program would be required to make a change in an architectural barrier. If the change is larger, obviously school districts would have a higher duty to provide those kinds of things. So I think what you really have to do is sort of look at the program, look at what needs to be done, and then try as best you can to figure out whether any claim that it is causing an undue burden is justified based on the resources of the program that's providing the child care program. Questions? As I said, no questions in this session, but again, I'm very happy to take questions when send me an email or the like. My contact information is here. I'd be interested in seeing what kind of barriers people are running into. So if you run into a problem, just let me know. I'll let Sharon know. Let me know.
Yes, absolutely. And I'm happy to be the go-between if anyone needs to do that. I will be sending out this PowerPoint right after we finish here. So for those of you who are in attendance, you'll receive the PowerPoint with all that information in writing. So I know we have a lot of staff from FHF centers, so you'll have this as a resource. Thank you so much for being here, Ron. We appreciate your time and your willingness to help us.
No problem. Take care.
You too.